Good morning, dear James Lofton. And it looks like there's a motion to revoke probation in Mr. Lofton's case and cause number 16-24485.
First case of the day, and the stakes are already high. Mr. Lofton's walking a legal tightrope, probation on the line. Plea deal dangled just in time. But here's the kicker. Courts don't hand out second chances like candy. So will the judge bite, or is this game over?
The announcement.
Your Honor, the announcement is the state has made us plea off. The plea we're probably going to take it, reset it for a date certain. Do that as I need to wrap up the case. Suspension order. Plea goes authorized.
Okay. When is the misdemeanor set?
Misdemeanor just in mid-set.
Which they'll always move it up if you need to. There's some issues like this. I don't want to get it off too.
No, I'd like.
Oh no, it'll be 30.
That's fine.
We're talking 2 or 3 weeks.
Yeah.
What did it's the when am I not? Do I have a day I'm not working? No.
I've got a trial already done. 18th of August.
All right, we're going to reset it to August 4th. That's 2 weeks for a plea on that motion. All right? We'll see you back then. We'll see. And Mr. Thornton is charged with fraudulent use possession of credit or debit cards in cause number 240323. And what is the announcement?
Your Honor, the state just made us plea off in the case. We're working on different background. So we should be able to get a court announcement in place. We sent the same day for state to set a plea.
Okay. All right. Because I know you haven't been on this one very long.
No.
You'll be good in 2 weeks.
Yes.
All right.
One way or another, we'll decide.
Okay.
We'll be on trial docket.
All right. We'll reset it a couple of weeks. Mr. Thornton, stay in touch with Mr. Barrington so you can visit about the case, and then we'll get an announcement the next.
Mr. Thornton's playing the waiting game, but when you're facing credit card fraud, that delay could either save you or set you up for a much harder fall. Will he clean it up in 2 weeks or gamble away his shot at leniency?
Okay. And this is 242420. Mr. Lane, what is the announcement?
The court has allowed me at least one announcement. Grant has been in treatment for many months. He recently got out of treatment. I tried to get in touch with him for us to meet to go over this matter. However, I've sent a really good mitigation packet. It's not really our issue. We filed last week about his recovery and all. So I'm hoping that maybe if you allow me one more announcement, we can work.
All right, so this will be the last announcement. You get with Mr. Nichols, Mr. Drake, make sure you stay in touch with Mr. Lane. So once he visits with Mr. Nichols, you'll know what your options are, and we'll get an announcement. It'll either plea or it will be going trial docket the next 2 weeks. Okay, you're free to go. Thank you, sir. Thank you, Mr. Lane. Good morning. You're Gustavo Vasquez. All right, so we reset the case last week, sentencing on Mr.
Next up, a defendant stuck between broken systems and mounting pressure. Mr. Vasquez isn't just fighting for probation, he's tangled in a mess where even the police won't return a judge's call. Yeah, you heard that right. Buckle up.
Made a phone call to Officer Clark, Port Arthur Police Department last week. I think it was on Wednesday, and have not heard back. So that obviously leads me to believe that there is an issue if he's not calling defendants back, but kind of feel like if the district judge calls you, you should call them back. So that I don't disagree that Mr. Vasquez, could possibly have done more, but I also don't disagree. It sounds like even probation has seen evidence that Mr. Vasquez has tried to do what he's supposed to do. And so based on that, I find it hard to revoke a probation when it looks like he's trying. Today, what I'm going to do after docket, since I have not received that call back, is talk to Chief over there about what is going on, because it sounds like this is not the only case where there's some issues. I also know that I think Jody tried to call correct and also gave an email address and did not get a response either from probation from this Officer Clark. So that being said, what I'm inclined to do, because that is really the primary allegation, is continue the probation and have Mr. Vasquez continue to try, obviously, to register, but potentially maybe go on higher caseload so that he has to report more. If he can't get that done for some amount of time, at least he'll be reporting to you more often and things like that. Is there anything else that you can think of that would be appropriate at this point? We're about to talk also about treatment and some stuff like that. Okay. So, Mr. Vasquez, obviously there's an issue with the reporting, but I still have some concerns because Dr. Asteris mentioned that your progress is below average and needs improvement, and that is not going to be acceptable after today. Do you understand? So you're going to do everything you're supposed to. You're going to continue to try to report, but I mean, regardless of that, you're going to do everything else on probation as well as possible. And below average and needs improvement is not going to be acceptable. It's just not. So what I'm going to do is, again, find that you entered your plea of true to count 2 freely and voluntarily. Find that count true. Find sufficient evidence to find you guilty and revoke your probation. I'm not going to do that. I'm going to continue that probation. You're going to be moved to a different caseload.
This isn't just a warning, it's a legal ultimatum. The judge gives Vasquez one last lifeline, but beneath her words is a hard truth. Rehabilitation isn't just about trying, it's about proving. And court patience, it's got an expiration date.
More often, at least for some amount of time until all of this gets worked out, okay? The concerns that I have are with you, and then I have just as big concerns with what's going on up there, because these are cases where obviously we need to know where everybody is. And if we don't have someone taking care of that in that office, then I think the community is at risk of bullying. So I'm gonna work on that separately. Let's see, was there any, I made a note. No. All right, that's really it. All right, so you need to make sure you attend every appointment with Dr. Asteris, follow through with everything you're supposed to, engage in that, whether you think you need it or not, you're ordered to do it. And so just going and showing up and doing the minimum amount of work is not going to work, because if you don't complete that in an appropriate way, it's a violation of your probation. Okay? All right. Y'all.
Like you said, Judge, you need to try to register.
Yes.
If you know who to call and what happened and report to the probation office, if you don't, that way she knows what to do.
I would say call every week until we get it worked out, and you are every single week. Leave a message. If he doesn't answer, don't just hang up. Leave a message with your name, what you're trying to do, and then that way there's some records. You write down every time you do that. Again, just like Mr. Parker said, let your probation officer know, and we'll hopefully get all that worked out. Okay? All right. Y'all are free to go. Thank you. Morning. Are you Mark Hebert? And will Mr. Hebert waive the formal reading of the indictment?
Yeah.
Mr. Hebert, in cause number 250455, you're charged with a third-degree felony offense of driving while intoxicated, third or more, from April 16th of 2024. The indictment alleges you were previously convicted of driving while intoxicated March 31st of 2010, and then after that, January 8th, 2013. How do you plead to that charge?
Mark Hurt is skating on thin ice. A third DWI. That's a third-degree felony in Texas, and the court doesn't play around with repeat offenders. He might be walking out today, but make no mistake, he's inches from a 5-year prison stretch.
Did you enter your plea of guilty and true freely and voluntarily? And because you actually did what they've charged you. And I have here on the computer some documents that have your signature on them. The state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year term in prison, but that would be probated for 5 years. You'd be on probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Also, it looks like there would be a dismissal, misdemeanor, what kind of condition?
It's harassment.
Okay. if I may hold off on that. Sure. Yes, sir. Yes, ma'am. Is that your understanding of the agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one. It's admitted. Is there any evidence that Mr. Hebert's not competent?
No.
All right, sir. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you at sentencing. Good morning. Are you John?
Felony theft, and the clock's ticking. Miss Cooper's already pleaded guilty, but don't be fooled, it's the judge who's holding all the cards now. Jail time, probation, a mix of both. Whatever happens next, it's going on her record and into the system's ledger.
There is an MTRPP as well as a new case in cause number 242485 and 15-23582. And what is the announcement?
Jim has birthday on this video, not formatted correctly. I'm trying to watch it. It is up.
Okay. I'm going to reset it. Make sure you work on that early so that we're not figuring that out on the day of court.
I am Judge.
Mr. Van Wright, if you'll stay in touch with Mr. Mitchell, once he gets all that worked out, technology part, you can go in, watch that with him. That way you'll be better equipped to make an announcement. Okay, perfect. Thank you. All right, thank you. Morning. Are you Alexis Bourgeois Cooper? And will your client waive the formal reading of the indictment?
Sure.
All right, Ms. Bourgeois Cooper, in cause number 241296, you're charged with the state jail felony offense of theft of property from April 8th, 2020. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. White? And do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 12 months in the state jail prison, which means you're leaving your punishment up to me. I can give you 12 months in the state jail prison. I can give you less. I can give you probation. It all depends on the information I get when we come back to Senate. You have an absolute right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not. And then if they found you guilty, you could leave your punishment up to them. If we go forward this way, you're waiving that right and you're leaving it up to me. Do you understand? And as long as I don't give you more than 12 months in state jail prison, you're waiving any right to appeal. You understand that as well. Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Bourgeois Cooper is not competent?
No.
All right, ma'am. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for a sentencing hearing. We'll get probation to do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, get that information to Mr. Lane. He'll present it to me on your behalf when we come back. And as you're leaving the courtroom today, you need to stop and talk to probation and that case right there.